Okay, so we've talked about dormant commerce and the general principles under dormant commerce, right? That if a law discriminates, you apply strict scrutiny. If it does not discriminate, you apply pike. And we've talked about how those work. We're entering now into a couple of different areas where there's a new principle that you have to be familiar with. And the principle is this. Think about it this way. This dormant commerce area of law is designed primarily to stop states from engaging in protectionism. Protectionism, okay. Make sure if you have a problem with that term or you want to understand that term a little better that you Google it and do some reading about it. Protectionism, generally speaking, is the propensity of a government, let's just call it a state, right, for purposes here, of a state, to regulate the market in a way that favors its own private interests, right, within the state. So I'm going to keep saying that. Regulate, right? Protectionism is regulating, please note these words, regulating, right, to favor private interests. Regulating to favor private interests, right, within the state. Right, so, and that means what? I'm trying to, if I'm Florida's government, I'm trying to give Florida's businesses a leg up in their competition with businesses from other states, right? I want to favor businesses in Florida, and I'm going to regulate, I'm going to pass laws to regulate in such a way that Florida businesses have an advantage over businesses from other states. Now, why is that so important? There are two principles. One is the principle that emerges in a case called United Haulers, which I'm not going to talk about in this video. I'll talk about it in the next one. But I just want to talk about the underlying principle here, where a city is discriminating with a flow control ordinance, right? But it's not discriminating in favor of in-state private businesses, right? It is discriminating in favor of itself, right? The city is discriminating in favor of a municipal corporation, right, which is again is run by the city, right, and is directing the flow of waste, right, to a city-run institution or municipal corporation. So I want to repeat, protectionism, right, which is the core thing that we're trying to prevent here, is a state regulating, and that includes subdivision of a state, regulating to favor private businesses right inside of the state, or in this case, the city. So, once you take that out of the equation, right, the government is not discriminating in favor of, first of all, it's not, let's put it this way, it's not both regulating and in favor of private businesses, right? If one of those is missing, it's not regulating, we'll get to that in a second, or it's not favoring private interests, it's favoring itself. Then you have a problem, right, where a court's going to say, under those circumstances, although there may be some discrimination going on, it's not the kind of discrimination that triggers strict scrutiny under a dormant commerce analysis. So, there are two exceptions, right? Now that we've got the general rules laid out, you need to know there are two exceptions to applying strict scrutiny in a dormant commerce case, even if the government is discriminating against out-of-staters. Okay, so we're going to revisit United Haulers in the next video and try to make that clear. The much more common, that's why I want to start with that, the much more common issue when it comes to an exception to strict scrutiny in a dormant commerce case is the issue of market participant. And I'm going to cover that in this video and another video because it's going to take a little while. In this video, we're going to cover a case called Reeves versus Stake, which is the case you read out of South Dakota, where South Dakota actually started a cement plant, right? So what happened? There's a cement shortage in South Dakota. You know, South Dakota is going to do what most states do if they have a shortage of private industry, is to try to incentivize, right, private companies to come into the state. Apparently it was nobody's life dream to produce cement in Minnesota, so no matter how much, in South Dakota, so no matter how much South Dakota incentivized, right, the production of cement in South Dakota, private businesses, for whatever reason, simply were not filling the need. So you've got a need, you've got a shortage, and you don't have private industry filling the gap, right, to come in and meet the need, the demand. So South Dakota says, all right, fine, we can't get anybody else to do it, we'll do it ourselves. And they open a cement plant, right? where they produce and sell cement. Now, something interesting happened in the course of South Dakota running its cement plant, which is, number one, they did a good job. Right? You hear a lot of people talking about how the government's not competent to do anything. Well, apparently in South Dakota they were competent to make cement because there was actually high quality cement. They made good cement. Number two, the only reason South Dakota was in the cement business was to fill, right, an unmet demand for cement. So they were not interested in a profit motive. So the profit, right, the profit part was of the price was skimmed off. So not only is South Dakota making cement, they're high quality cement, they're also making it for cheap prices, right? Now, you know, if I had to ask you, how long do you suppose it took, right, for construction companies around the country to figure out that South Dakota is making high quality cement at low prices, right? Of course they figured that out. And so now the next thing you know is, right, you have people from, right, corporations, mostly construction companies from around the country, wanting to buy their cement from South Dakota. South Dakota says, no, we are not selling to out-of-staters, right, unless and until we have satisfied in-state demand for cement. After all, satisfying in-state demand is the reason why we started the cement plant to begin with. Now, do you see discrimination there, right? The state of South Dakota says, we will not sell to out-of-staters until we have satisfied the demand of in-staters for the cement. I hope your answer was yes. That is obviously discriminatory, right, against out-of-staters. So in a normal case, you'd say, well, that would trigger what? What scrutiny? Everybody say it out loud. Right, strict scrutiny, right. Let's, however, revisit the principle I just talked about. Strict scrutiny applies in a dormant commerce case, right, when courts are wary of states regulating, and listen to this, like regulating in favor of in-state private business interests. Okay. Now, what's going on in the South Dakota case? Is South Dakota regulating the market, right? Because why do you think of it? You can almost think of those as elements, right? Yeah, okay, when you see discrimination, you get strict scrutiny, but that requires that the state regulate in favor of private, right, in-state business interests. So when South Dakota, right, opened a cement plant to manufacture and sell cement, was South Dakota regulating the market? And you know where this is going because you know the name of the principle is market participant. And what the court says is, no, South Dakota was not regulating the market in a discriminatory way. South Dakota was participating in the market, right? It got into the market. That's not how states usually behave, right, when they're trying to create protectionist measures, right? Again, protectionist measures, I'm going to keep saying it, protectionist measures usually exist to favor, right, corporations, right, and businesses within the state. So if I'm South Dakota and I want to, you know, protectionism would mean that I want to give South Dakota cement companies a leg up on other cement companies. That's not what South Dakota did. They didn't regulate in a way to give South Dakota private cement companies a leg up. They got into business themselves. That is called participating in the market. And what the court said is when you're participating in the market, rather than regulating the market, you kind of lose the character of a state regulator, and we don't have a dormant commerce problem. You know, we're only applying these dormant commerce principles when the state is regulating the market. And if you're participating in the market, we're basically going to treat you like any other private participant in the market. And like any other private participant in the market, you can sell to whoever you want to, right? In terms of the state they're coming from. If a private cement company wants to sell to in-state buyers, then they can do that. That is the general principle of market participant, right? You're looking at, again, and here with the market participant, you really have a problem with both the regulating part and the private businesses part, right? The state of South Dakota wasn't regulating, it was participating, and it was not in favor of private businesses, it was in favor of the state's own business, right? So discriminating on behalf of themselves, South Dakota, rather than businesses in South Dakota. I know that's a lot to take in, but if you need to keep rewinding this and re-listening to it, I don't think there's too many better ways I can put it than that. Right? If the state is a market participant, it is not regulating the market, it is participating in the market. If it is a market participant, then it is allowed to discriminate without facing strict scrutiny. Right? And you don't do pike either, right? You just go straight to rational basis. Don't even worry about that. I mean, for dormant commerce purposes, if the state is a market participant, the case is over, okay? And the state is allowed to discriminate, and there's nothing else to talk about. So with that as backdrop, in the next video, we'll get to United Haulers, which is a pretty confusing case. I'm not a big fan of it, but it's out there, so we have to cover it. But that's enough for the South Dakota case and the basic principle, right, that there are some cases, rare cases, where even if the state does discriminate, strict scrutiny does not apply. So we'll see you for the next one.